For those of you who are still getting your food, please feel free to continue through the line. We're going to go ahead and get started. Again, we do have people on Zoom with us this afternoon. So for the purpose of those of you who are on Zoom, my name is Karen Winkler, and I am the CEO of the Montana Association of Realtors. And we are very pleased today to be able to welcome NAR President Kevin Sears to be with us today. Not to mention our own President DJ Smith and the other guy. And our legal counsel, Jaymie Bowditch, who is getting a workout the last couple months. So we did ask people to submit questions ahead of time. So those questions have been reworded a little bit for some people. And have been given to DJ, will be our moderator today. We are hoping to have time at the end to do some question and answer. But again, if we get to that point, please be concise. Please limit your question to maybe just a one-part question, and be aware that the answer may be we do not know or we can't answer for legal reasons. And that would be $25 for our pack. So welcoming to the stage, DJ, Kevin, and Jaymie.
Thank you, Karen. Well, thanks for coming, Kevin. We're really excited to welcome you to the Big Sky state. That is, I know when we reached out to NAR and said, who do we get? And they said, oh, you'll get Kevin. We were all shocked a little bit. Yeah.
Yeah, no, I'm thrilled to be back in Montana. So thank you for the hospitality, and I appreciate being here and being educated yesterday. I sat through the implicit bias training because one of the policies that we have in place is if you want to serve on the board of directors at the National Association of Realtors, you have to go through the training, fair haven, implicit bias, all that stuff. And I figured, since I have to chair that meeting in May, I should really make sure I'm not ineligible to be a director. So,
yeah. Well, I'm glad I wasn't the only one required to be there, but I know both of you have been incredibly busy since the settlement announcement.
Why? Is there something going on?
I don't know.
In the leadership, they said it'll be fun. They said. Yeah. I think I'm going to write a book, and the title of my book is going to be "How to Lead in Boring and Uneventful Times." And I named the title. The book is over because I don't know what that is. So yeah.
I mean, look at that engagement that you've got so far. So you're doing something right.
Yeah.
So really appreciate you being here. As you can imagine, we probably fielded a lot of questions from the audience. And one of the largest ones, and I was debating if I go softball or just a hard pitch right off the get-go. I welcomed you, so that was the softball.
Brush me back.
Yeah. You know, the hard part that I think our members are dealing with is just the overall narrative around this. And I know your team has been working on changing that narrative. You want to give more insight on that?
So that's a loaded question. It really is. Let's go back 8, 10 months ago, 12 months ago. The national media was not kind to us, to our industry, to our association, to our leadership. And we've had some transitions that have happened. One of the things was last fall after the first resignation. I'll tell you that there was a void, a vacuum in our communications. And unfortunately, it was being filled by others, and not necessarily the truth or the best narrative. January 8th, when I became president, after the second resignation, one of the things that I said to the team was, I said, we need to do a better job communicating with the members because of what happened in the fall. And it was a tough period. But what happened in between then was for nearly 8 months, we did not have a senior vice president that oversaw the communications department at the National Association. And so it was a ship without a rudder, a ship without a sail in the communications department. They just were, it was aimless, right? So we hired somebody in December, ton of experience. She is a very smart person and has been a tremendous asset for us since December. But what I said was, we need to do a better job communicating with the members first. And so I did a video that first week and received some feedback that was critical. But I like critical feedback because the person that was critical about the video said, You know, don't stop being scripted. Don't read the teleprompter. Don't, you know, give the NAR speak. And so what I appreciate about a critical thinker is like this person was, he didn't pull the pin out of the grenade and toss it. He offered suggestions of what to do to improve it. And out of that came the on the road videos that I've been producing. I'm sorry, that I've been in and NAR has produced for me. And despite what some of the critics will say, I'll tell you, there's no green screen, there's no teleprompter. Instead, it's me for a couple of minutes just communicating with the members. And so I hope that you all are getting those videos and you see them. I'm going to give some high level things and then just, you know, maybe a little commercial about signing up for the ABR course for free at NAR. Become.abr.realtor. And you can take the first ABR course at $295 value for free, and you can get on your way to earning the designation. So we're communicating better with the members now, I believe. But the issue really is the national media.
Yeah.
Right. The national media. What I'll tell you on March 15th, yes, we signed the settlement agreement on the Ides of March. We had agreed in the settlement that we would not disclose the terms of the settlement until 10 a.m. Eastern on March 15th. At around 9 a.m. Eastern on March 15th, the New York Times published an article with all sorts of inaccurate information, quoting the plaintiffs, and that's how the narrative began. And so what we know about headlines is when there's factual errors, the correction is never broadcast the same way as the initial headline. So we had a plan, and unfortunately, it was undone based on what the New York Times did, because I don't know if the journalists are just lazy or inept, but they didn't call asking us for the facts, and instead ran with what the New York Times said, because they figured, hey, if the New York Times is printing it, then it must be correct. And it wasn't. So that's where what I've been saying is, let's not focus on the national media. We are a grassroots organization. Mm-hmm. We've got 1.5+ million members across the country, members in every community. It's the local media for me that matters. Keep volunteering with the PTO on the sidelines of the Little League field. Be in the soup kitchens, help at the habitat build, and then tell our elected officials, our regulators, the media, the local media about the good work that realtors do in the community, because that's really where the rubber meets the road. So I will just say, I'm sorry that you've probably had to deal with some of your clients who saw the national media, the inaccurate information being provided, but I want to thank you for correcting that information, because that's what we need to do.
Right. Everybody has a plan until they get punched in the nose or are sitting on the top of a high dive on fire. Pretty much, Kevin.
I know you guys are launching a surrogate program where realtors in the community.
A media surrogate program. Yes.
Okay.
Yeah.
Thank you for that clarity. That brings it. Jaymie, to bring you into this conversation, I mean, we all got noticed at the same time, and I'm guessing your phone has been ringing off the hooks quite a bit. And from our members asking how, now that NAR has settled, what does this mean to our members? And a couple of those things are forms. Do you want to kind of dive into that real quick?
Yeah. So, you know, I just actually told Kevin 5 minutes ago that, you know, one of the things that I am lucky enough to do is to be able to get on a closed Zoom call with the NAR legal team with other state councils across the country. And, you know, NAR started doing this actually on November 1st at 9 a.m. right after the verdict. And, you know, since the settlement has been very proactive in getting information out. And we had a great call yesterday, probably actually one of the best calls that I've had in a very, very long time, where there was, you know, we're finally getting to the point with respect to the settlement terms that we can, you know, filter through the questions that are coming out, legitimate questions. And I'll tell you this, you know, the questions that you all have and are asking me and asking your representatives at the NAR leadership are almost identical to the questions that are being asked around the country. So NAR was very kind to provide, I would say, a significant, well, NAR legal, a significant amount of guidance as to kind of how this is going to start shaping up and looking and putting some sideboards on what the settlement terms will look like, which is fantastic, because as a organization, our form subcommittee will be meeting on April 23rd here in Helena to start the discussion about some of those form changes. And we will be meeting again in May. I can't remember the date, I think the 20th. Angela told me earlier and I already forgot, but to actually take and really, that will be specifically focused on making changes that we feel are necessary as a result of the terms of the settlement. And the last thing I'll say is, don't forget that, back in December or November, December time period, when the verdict came down and we started to kind of get a little idea of perhaps the position of the Department of Justice, in part through some of the settlements with Keller Williams, Remax, and Anywhere, we started and did make modifications to the forms. And I won't say that all of the terms of the settlement agreement are currently addressed in our forms, but some of them are. And as everybody knows, we're one of the few states or the minority states in the country that have a requirement statutorily that a buyer representation agreement be executed. So
there are 18 states across the country that have it.
Yeah.
Another handful have some legislation that's making its way through. And I bet in the coming years that we'll see all 50 states.
yeah, there are a couple that are going into, they've already got the legislation passed. They'll go into effect
Yeah.
January 1st of 2025.
Yeah, Oregon is one of them.
Yeah, Oregon, that's right. So I'm comfortable. I mean, there's still some stuff to figure out, and we're still obviously gathering information as fast as we can. But we are well positioned as a state organization to make certain that the forms are going to be ready and that information will be provided to you, but on or prior to the deadline that is the 120 days from the date the settlement approval motion is filed, which I hear is hopefully next week.
Yeah, I was hoping it was going to be this week. I was hoping it was going to be last week. So I don't know. I don't know why the plaintiff's attorney hasn't filed it yet. Can I just touch on something else about the settlement?
Yeah.
So the settlement is a proposed settlement. Understand that it has to be filed in the court. We need to get preliminary approval first, and then it'll probably be 6 months or so after preliminary approval that hopefully we'll get final approval. So we're implementing the rule changes in advance of final approval, and there's a very specific reason. The rule changes will go into effect at the same time that the class is notified. So those postcards that maybe some of your clients have received, there's going to be another round of those going out. And the reason that we're changing the rules then is because once the notice goes out, the clock restarts. And if we have the old rules in place after the notice goes out, we could actually be liable after the notice for any claims until the rules are changed. So that's what it is, but it's a preliminary approval is what we're going for first, final approval at the end of the year. And then, the other piece, and I'm sure we'll get into the rules, but there's a financial component. And the National Association of Realtors, we agreed to pay $418 million. That will be over the next 4 years approximately. $202 million is the first payment. It's actually $5 million we need to pay within the next 30 days after it's filed for preliminary approval. 197, 90 days after, within 90 days of final approval, and then $72 million a year on the anniversary of that first payment. Let me be clear and tell you, in 2024 and 2025, the dues for the National Association of Realtors will not go up. There will be no additional charges for the members for this year or for next year. And we're actually meeting with some financial experts, outside folks, next week with the leadership team, and we're going to do a deep dive into the finances of NAR and look at everything is going to be on the table, what we have, so that we can make sure that we meet our financial obligation, because we need to make sure we do that so the settlement will go into effect.
There's something you mentioned in there about liability. One of the biggest questions I think we're receiving right now is, okay, great, NAR's covered, but what about us? So can you go into a little bit detail about the elements that you fought for?
Yeah, so the settlement, what we fought for from the get-go was protecting as many of our members, associations and MLSs as we could. Well over 1 million of our members are protected based on the settlement. With some of the corporate settlements that happened before our settlement, the agents in those brokerages or under those umbrellas were protected. So well over 1.4 million of our members are protected. There were some carve-outs. So members are protected. If you're an independent contractor, you're a realtor member, you're protected. Unless you're part of Berkshire Hathaway Home Services or one of their affiliates. because they are the final defendant in this case. And so they were carved out. Corporate brokerages that had over 2 billion in sales in 2022, the corporate entity was carved out, but their agents were protected. All local associations, state associations, territorial associations, and association-owned MLSs are protected. So long as the rule changes go into effect, that's one of the key points here. And then the
MLS files their statement of agreement.
Yeah, and then for the non-association owned MLSs and those brokerages that I talked about, approximately 96 of the corporate entities, there were two things negotiated into the settlement on their behalf. And it was so that they could opt into the settlement, and they could either do there's a formula that's a fixed formula on what they would have to pay to get a release, or they could do non-binding mediation. So those are two options that we were able to negotiate into the settlement on their behalf. But at the end of the day, they can negotiate on their own, and they can look at, risk management. We're all, realtors, and risk management's a big thing. They can say, you know what, we're going to take our chances.
The good news, I think in Montana, we don't have any brokerage that actually meets that qualification. So all of, other than Berkshire Hathaway, other than that, most of them are met. Just a follow-up, Jaymie, and transitioning more to practice changes, because I think it's good news to hear that our dues aren't going up. That's a practical change, but changing how we do business. One of the big questions that we got is, okay, great. We have a listing agreement that's going up, and what happens if we don't sell it by July? What should we do? What should we anticipate in regards to that? Do you have any advice?
Well, it depends on exactly what, I'll say it this way. So with respect to the MLS listing agreements that are up there and offer SOC, you can still offer compensation right now, but you're not going to be able to once the practice changes go into effect. So, you're going to want to make certain that you're amending your listing agreement or signing a new listing agreement.
So I just want to clarify. You can still offer cooperating compensation. It just cannot be conveyed on the MLS. Don't try and be cute and put in the remarks or anything like that. You'll open yourself up to liability. You can offer cooperating compensation. You just cannot use the MLS as a vehicle.
Yeah, excellent point, and thanks for clarifying that. As far as if that question is, should I then, if I have a listing that's going to continue on past the effective date, let's just call it, should I amend my contract to bring it in line with the listing agreement as it will be modified? My suggestion would be, yeah, you definitely should.
Just following up on that same with another major form, the buy sell. 16-16, as you're probably getting a lot of questions right now. There's a lot of misunderstanding in regards to how that applies when talking about commission in a buy sell. Either one of you want to jump in on the applicability?
Let me start.
You can start, yeah. All right.
Yeah. So, and just to kind of set the stage a little bit, on the call yesterday, exactly 12 hours ago or 24 hours ago, actually, NAR recognized that, 16-16 is drafted is perhaps a little confusing in light of what is permissible. I don't think they will or need to, for that matter, change 16-16, but what they will do is get out a bunch more material and information and be more proactive in educating people as to what is permissible under standard practice 16-16. As a reminder, this is the standard practice under Article 16 that prohibits in some circumstances trying to adjust or modify compensation through the use of the buy-sell agreement. But what obviously in situations now now we're kind of talking about no offer of compensation on the MLS, as Kevin just mentioned. We're going to have to look at alternative ways to address situations where a seller or seller agent may be offering compensation to the buyer agent. And the the buy-sell agreement is one area where that can be done, as long as the language is directed at the seller, either providing the compensation to the buyer agent, or it is the seller providing reimbursement to the buyer to compensate the buyer agent. But so, to clarify, 16-16 as it's drafted, as interpreted, including I want to say case interpretation, but it's not called that NAR has out there, prohibits you from attempting to modify the offer of compensation being offered by the seller agent typically on the MLS. So, the long way of saying that we may be looking at, and I would say we probably will be looking at, putting language into the buy-sell agreement that provides some alternatives for buyers to request either reimbursement or compensation of their representative by the seller.
One of the larger practice changes is the requirement to sign a written agreement prior to showing property. There's a sentiment within agents that feel like this might promote dual agency. And so, Kevin, do you have any specific guidance on that?
Yeah, I'd be interested in having the conversation with the person that think that it would promote dual agency. Yeah, one of the things that we did was we were very specific in language in the settlement, and it's a written agreement with a buyer, because there are some states where it's transactional brokerage, and so they can't sign a buyer rep agreement. So, but people ask about an open house, or if they're going to have a buyer, an unrepresented buyer, come into their listing, they're going to show it to. So the question is, you need to have a written agreement with them explaining the services that you will provide and the compensation you're looking to get paid. If you're not looking to get paid by that buyer because you're the listing agent and the seller, well, then your fiduciary is to the seller. And in Massachusetts, we have agency law, and I have an agency disclosure form that needs to be given to the consumer. And I would state that I'm the seller's agent, the seller's representative. So where there's a possibility for dual agency, follow your license law. There doesn't have to be, right? But yeah, it's going to be tricky for some folks. Massachusetts is not mandated that you sign up a buyer rep agreement. But knowing what was happening, I had a client in December reach out to me and said, "Hey, Kevin, I need to buy a new house. I need to be out of the current house by February 15th. Can you help me?" I said, "Sure." So I went into our state forms, got the buyer rep contract, sat down with the buyer, first time I ever did it, and had them sign the buyer rep agreement. And in it, I explained all the services that I was going to provide, the compensation I was looking to get paid at the time, and currently you can still see what the compensation is being offered on the MLS. And I pointed on the MLS sheet and I said, "This is where you'll see that field. And just know that if that number is less than what's on the contract, you're going to have to make up the difference for me at the closing." So what I'm saying to you, you guys have been doing for years because you have it here in Montana. That was the first time I did it. And my buyer, my client says, "Kevin, that makes perfect sense." So I'm just telling you what you already know. When you can clearly explain your value to the consumer, this is going to give us another opportunity to have conversations with the consumer to explain our value and what we're going to be able to provide the services in the transaction. That's a good thing when we get to have more conversations with them.
A follow-up on the buyer broker, the question around enforcement, who's going to be enforcing that is signed prior to a show?
So the rule change is that any MLS subscriber needs to have the written agreement signed by a buyer before showing the property. It's going to be a rule change for the MLS. So the MLS will be the enforcement arm. Now, all I'll say is I'm sure there is a rule in your MLS that says you must have a written agreement for a listing. My MLS doesn't check my listing agreements unless there's a problem, right? So the MLS is going to have to figure out what they're going to do for monitoring that their subscribers are following the rules, just like any other rule that would be in there.
Great. Now changing gears a little bit to you, Jaymie, one of the questions that continually comes up is the fear that a buyer's not going to pay a buyer's agent at the very end. And what are some actions that they can do? People have asked, can they put a lien on the house? Can you jump into that a little bit?
You bet. Yeah. So Montana, and in fact, most states, in fact, I don't know of any state that has lien laws in a residential concept. There are some states, very few though, that have the ability to file a lien on property in a commercial transaction. Many years ago, we took a run at introducing some legislation on liens, and we didn't get very far at all. I don't even think the bill was introduced, so I don't foresee that's going to be a right forthcoming. So, you don't have that statutory right to just file like you do if you're a contractor on a construction lien. So, you're going to have to either, if there's, if you're going to be relying heavily on the buyer to be paying your compensation, you're going to do what attorneys sometimes do, right? You might want to seek retainer up front. You're going to submit your compensation to the closing agent and hope that it gets paid. If it doesn't get paid, and the transaction closes, what are you going to do? Well, you've got legal contractual rights to enforce that. And if you want to go to court and enforce that, you ultimately get a judgment, then you do have a lien. So, you know, these are things that we're going to have to work through a little bit. And, you know, but that's kind of, you know, as far as the lien rights, no. And, you know, if you're telling me to look into my crystal ball, do I foresee that we'll have lien rights in the near future? I think the answer is almost certainly not.
On the same vein of a broker agreement, as we call it in Montana, is there certain rules through the settlement or through state law that requires a certain time limit? So if you get the call from a buyer that wants to look at a house on Saturday, is there a certain time limit in which a buyer broker?
So I'll jump in here first on the settlement. No, you could say, I'm giving you a written agreement for this one house I'm going to show you. Or it could be for a weekend. That is not part of the settlement. You get to determine with the prospective client what the terms of the agreement are going to be, how long it's going to be. I'll let you talk about Montana state law.
No, you nailed it, Kevin. You know, there's no minimum required for a length of a buyer representation agreement. And so you can have it for a day, for a weekend. You can have it for a specific property if you want to do that. And the terms of the settlement, correct me if I'm wrong here, Kevin, because I'm thinking back to the last time I looked at it, is that it isn't required that your buyer broker agreement specify any compensation at all. It's only required that if you are going to get paid, that you have to clearly disclose and specifically detail how that compensation will work, or how the amount, how it will be calculated, or how the amount will what the amount will be. So, you know, if you want to do, if somebody walks into your office on a Friday afternoon and says, hey, can we go spend 3 hours in the car on Saturday and look at these 3 houses that I found? I'm not really, and you're a little nervous and they're a little nervous about entering into a buyer broker agreement that commits them to pay a substantial amount of compensation to you. Enter into a contract for a couple of days or a day, you know, and it can say nothing. But then if they find a house and they want to make an offer on that house, well, guess what? So
one other thing I will tell you that is part of the settlement is when you enter into that agreement with the buyer and you state what you're looking to be compensated, if the offer of compensation by the seller broker, the seller, is higher than what you put in your contract, you cannot collect above what you put in the contract. Now, the only thing I will say, I'm not a lawyer, but I know contracts can be amended. So just be very thoughtful about your approach with that.
So I'll enlighten Kevin on this a little bit from the conversation yesterday. And so, yeah, that was, in fact, what Kevin says is exactly what I've said. But, you know, yesterday in the conversations with NAR Legal, and understand, right, this is NAR kind of being very, very kind in giving their interpretations, which makes sense to me, is that they feel that, you know, as long as you approach your buyer, clearly disclose to your buyer what you want to do, and clearly negotiate and therefore document that you are going to be paid, you're going to amend your buyer representation agreement to get paid what the selling off or the offer of compensation is, they think that probably would be okay. Why? Because it is being transparent, it is being negotiated, and it is being discussed and agreed upon. It's got to be all up front. Now, you know, the practical side of things, if you go to your buyer and you say, hey, I'm getting offered more compensation over here, be prepared for the buyer to say, I'd like some of that. So, you know, just so you know.
One of the questions we get quite a bit right now, and I think there's twofold to this. The first question is NAR going to be providing scripts on these conversations about buyer representation?
Are we going to provide scripts? No, what we're going to do is we're going to look to NAR and say, hey, you've been doing this for years. Can you help? No, are we going to provide scripts? Well, so I mentioned the ABR training that we're offering the first course for free. That is the accredited buyer representation course. So education is out there. Scripts, I mean, I suppose we could, but it's really about educating, having the brokers. Well, actually, let me back up. Yeah, you know what? Turn to your broker.
There you go.
Sorry for the broker owners in the room. Turn to your broker for guidance, right?
Yeah.
Well, and let me just jump in on that. And I mean, I suspect, yeah, NAR is not going to provide any type of scripts, but you need to understand, and we've talked about this before, NAR has some excellent materials. And yes, there's realtor.fax with all the settlement information, but it's 179 and 180, or I can't remember the way, but it's the document that NAR produced that says, hey, you want to talk about value? Here's some bullet points, 179 of them, whatever. And it's actually very, very good to try to show the value that you bring to the table.
Yeah, 179 things that could happen in a typical buy-side transaction.
Yeah. And I mean, if you haven't pulled that down, you should look at it, because that's going to help you have the narrative that some people may want NAR to script.
You can get that at competition.realtor. You can get the 179, the list, and then it's facts.realtor, not realtors.facts, facts.realtor, where you
I
can
just
get,
Google it.
yeah, where you can get all the settlement information. We've got some great FAQs and all sorts of resources available.
So there's been a lot of questions in regards to some recent advocacy efforts of NAR around interested party contributions, as well as, I don't know if you know this, but in the state of Montana, 1 out of 10 residents are a veteran. And that drastically, the settlement's drastically changing how that conversation's happening. So any insight on the interested party FHA?
Yeah, so we received a letter from HUD a week and a half ago that said, so long as if the seller is going to pay cooperating compensation to the buyer's broker, and it's the normal course of business, they're not going to treat it as an interested party contribution, which has a specific limit as to how much they can get for closing costs, that sort of thing. So we have clear guidance from HUD on that. So we're covered. With regards to VA, well, 1 out of 10 of your residents are veterans. In yesterday's class, I would say 75% of the people raised their hand when they said they work with veterans. You currently have this situation right now, and you're working with them with a buyer agreement. So it's just making sure that you communicate what it is, how you expect to get paid. And with regards to 16-16, it's no, just be clear. And yeah, you're going to ask for the compensation to be paid by the seller or part of the contract, however you're going to do it, because we know VA buyers can't pay those fees. So how do you deal with them now? So there's going to be continuation on that.
Yeah, and that's not the end of the story. I mean, NAR is continuing to work with Veterans Administration to look into whether there's some changes that can be made. You know, it's probably not going to happen quickly, but they're doing everything they can.
Yeah, we sent the letter to them. We've had conversations. Here's the reality. The rules took decades to make. I'm not going to say they take decades to change, but it's not going to happen today, tomorrow, next week, next month, maybe not even next year. But we're having the conversations about what we can do for some flexibility there.
Yep.
One of the other a very large piece of the practice is obviously commission can't be posted on the MLS past July. There's a lot of conversations of, okay, so it's not here, then where? Some people have brought up their individual brokerages, brokerage websites. Jaymie, you want to jump in, and then maybe Kevin, if you can add.
Yeah, this is one of the terms of settlement agreement that I'm still trying to sift through. I had an interesting conversation yesterday with Charlie Lee and Jose Mucho on that Zoom call. But, you know, I think there's still some uncertainty in this area. And so I would caution you to take anything that I'm about to say and implement it as a practice change immediately. But you may be able to, you know, here's what you're not going to be able to do, right? You cannot have an offer of compensation on the MLS anywhere, right? Agent remarks, doesn't matter, nowhere. You can't have something in the agent remarks that says, here's a link to my personal Jaymie's website where my compensation policies are in place. That's not going to be permitted either. Could you have some language in there that says, contact the listing agent about potential offers of compensation? You know, that seems to be a possibility that may be available, but like I said, a little bit TBD. I think right now, you know, the best advice is going to be, I don't know that you're necessarily, I suspect you're going to get calls as a listing agent, regardless of whether there's an offer of compensation. So I'm not so sure communicating whether there is or isn't is going to be that important. But it could be.
So what I can tell you is if you receive an IDX feed for your company website, you are allowed under the settlement to post on your own website what the offer of compensation is for your listings only. So that can be a vehicle for agents. If you're posting it on your own website, there's an offer of compensation. Agents can do that. My suggestion is, we might have to pick up the phone and make calls again like we used to. But if you're asking the listing broker if there's gonna be an offer of compensation, just for practical purposes, I'd want to get it in writing, text message, email, however it is. At least that way you can point back if there's a dispute, say, well, you told me it was going to be this, right? So at least you can post it on your own website. One other thing, and I'll tell you, is on the MLS, you will be allowed to have seller concessions, a seller concession field. So if the seller is going to offer a concession for closing costs, the repairs, whatever it is, that can still be on and maintained on the MLS. What cannot happen is that the concession field have an amount in there that could be comparable to what you would expect as a buyer rep compensation or cooperating compensation. So just be very careful on it, be very diligent and specific, but seller concessions will still be allowed to be communicated on the MLS.
Yeah, and that's a great point to bring up, and maybe just a practice pointer. Again, part of the discussion we had yesterday is, you know, remember this, and I think you're going to start seeing more, excuse me, seller concessions than you used to. Remember this: seller concessions on an MLS or a website are not a contractual obligation. So if there's a seller concession of some amounts to go towards your buyer's closing costs or whatever the case may be, and you're representing the buyer, you must put that into the buy-sell agreement. Don't just rely on what's up there, or you're not going to be able to enforce it. And number two is, NAR felt, and I would tend to agree, that if there are seller concessions of X amount sitting on the MLS, and you can use that money for buyer representation or buyer compensation. You can even put it into the buy-sell that that's what you're going to do, but it just can't be, the seller can't say on the MLS, I am offering concessions of X, provided that you agree as a buyer or buyer agent that it will go towards compensation and only compensation. That is strictly prohibited.
Great. We're kind of getting to the tail end of the questions that we had prepared. So Karin, if we want to grab that mic. The one that kind of lingering back out there is the judge. We're still waiting on first the motion, then the judge approval. But is NAR moving forward with these rules changes no matter what?
Yes. Yeah. So there is something else that you touched on a little bit in one of your first answers. We're moving forward with the rule changes, right? If for some reason we don't have final approval, we don't get it, well, then, and the settlement isn't approved, then we're going to have to deal with it at that point. But knowing that we lost or were found liable in a court case and had a huge jury verdict against us, you know, are we going to change them back? But one of the things that you touched on is the Department of Justice. People have been asking, can the Department of Justice prevent this settlement from going through? And the answer is no. We saw in the Boston case that they filed a brief statement of interest on February 15th. And that gave us very clear guidance as to what the Department of Justice is looking for. They want a complete decoupling of compensation. They even propose that we get paid as a buyer rep on an hourly basis. What I'll tell you is about the Department of Justice is they have different divisions. And so we're dealing with the antitrust division. And we've been pleading with them to talk to their division that handles discrimination, fair housing, that sort of thing. But they're not communicating. There are firewalls up because we talk to them about who we think are going to be the parties that are going to be harmed the most. First-time buyers, first generation Americans, you know, buyers, people of color, immigrants. It's like the folks that are the most vulnerable are going to be the ones that we believe are going to be harmed the most. And they're the ones that need the representation the most, quite frankly. The plaintiff's attorney pointed to Australia and the United Kingdom, saying commission rates are so much less. What he failed to do, because it's apples and oranges, there's no buyer representation. The commission that is paid commission is less, but they didn't talk about all the fees that are a la carte that have to be paid on top that equal or surpass what the average commission is across the country here in the US. And I'm not going to say numbers, but they also failed to talk about, in Australia, I was talking with the president, the CEO of Realtor.com, Damien Eales. He is from Australia. He's living here in the States now, but he said 30% of the transactions fall apart. because there's no buyer representation. There's no professional guiding the buyer through the process. So, anyways, I went off on a tangent. Department of Justice, they will likely file a statement of interest. The judge in Massachusetts really did care about what the Department of Justice had to say. I don't know if the judge in the 8th District in Missouri is going to care much about what the Department of Justice has to say. We'll find out, but the Department of Justice cannot prevent the settlement from happening. They can just weigh in.
The one last question that I missed earlier was, and does any of these policy changes contradict clear cooperation policy?
I mean.
So all I'll say is I was really up on the clear cooperation policy stuff last fall. And then with this verdict, I've just kind of been around. But the clear cooperation policy in the Department of Justice had an interest in that as well. Yeah, okay. It's starting to come back.
Yeah,
Sorry.
I don't see that, not directly, put it that way. But the clear cooperation policy is one of the pieces of the puzzle that forms what the basis for the lawsuit was, right? The clear cooperation policy, the mandatory offer of compensation, blanket unilateral. But the clear cooperation policy requires you to upload to a MLS, a listing within 1 business day of public marketing it. That's not inconsistent with the terms of the settlement. Now you're just going to have to upload an MLS for which there's no offer of compensation. So does that mean clear cooperation is here to stay? I don't know. Certainly probably one of the targets of the DOJ's statement of interest, but I think that's to be determined as well.
Right. As we transition to floor questions, a couple ground rules. Please do not give a story before the question. Ask the question only.
So DJ asked if I was going to give the ground rules, and one of the things that we've done, I think the first question was about the communications, and on March 15th, we had a cascade of communications, and we went through all of them, different groups that we were talking to. One of the things we said was, we'll continue to have in the weeks ahead, months ahead, town hall forums, that sort of thing. And I had the National Association Board of Directors town hall last week, and I set the ground rules. So, okay, we've got 1,000 directors here. I'm not saying that we're going to get 1,000 questions, but I want to be respectful of all of you. So these are my rules. Do not give a 1, 2, or 3 minute prologue before asking a question. Please be as concise as possible so that we can get through as many questions as possible. And then I also said, and this meeting will end at 1 p.m. It was Eastern time, 1 p.m. And we ended at that time. So people were very respectful in that. And so I did appreciate it. But yeah. he was asking me, you going to say the rules? And I said, no, but now I just did.
I listened to the rules. Yeah. The other piece that I will say.
Oh, and I'm sorry. And I said, if there's more information we need to answer the question, we'll ask you, but be concise in asking your question.
Yeah. The other thing that I will just say is if there is a question that we will not answer, we will not answer. And so please, Karin, be prepared to yank that mic away from our members. Okay. With that being said, in an orderly fashion, do we have questions? Yes, Bill. We're going to go this way first, Mark, because then Bill's in the very back. So let's go Mark first. Mark.
Yeah, I'm just would like to know the breadth of the release that the coverage that we're getting as realtors. Who is the releasing class? What's the breadth of the protection? Does it include all sellers everywhere? Does it include buyers?
If the judge approves it, it's the seller side. All sellers nationwide. And I think it's for the past 7 years, even though the statute of limitation might only be 4 or 5. So it is a very broad release.
Okay, great. Thank you.
Yep.
I'm coming, Bill.
Bill, we're going to wait because there are several on Zoom. Okay.
A little off topic. How is the CEO search going? Kevin, we can't thank you enough for giving up your life for 2 years instead of 1. Incredible commitment to our organization. But with that, steering the ship, I know Ms. Wright is doing a great job, but what can you tell us?
So what I can tell you is back in February, before the settlement was announced, we have other things, issues that are going on at the National Association of Realtors based on what transpired last year. And so we have a Culture Transformation Commission that is doing their work. They're going to be making some suggestions for policy change, what we can do to make sure that we provide a safe place to work, a safe place for volunteers and staff to be able to collaborate. And so in February, I was talking with Nakia Wright, our interim CEO, and I said, I know we signed you to a short-term contract, right? They said, but how much time can we have from you? How much extra time can we have? Because, you know, what myself and the leadership team were thinking about was we've got multiple presidents in a short period. We've got all these issues that we need to right the ship and the culture of the association. You know, having multiple CEOs in that same time frame could just add to chaos and confusion. And so she said, Kevin, I am so glad you're asking me that question, because I was thinking about that. There's some things that I want to see finished before I leave. And so we ended up extending her contract through the end of the year. So we have her through the end of the year. Now that we have the settlement and the dust is settling on that, my goal is in the second quarter to put together a search committee and task them with a nationwide search for our next CEO, and knowing that we've got until the end of the year to find someone.
Great.
Yep.
Awesome.
I have a question. This has to do with what happens after the sale. Now, we can't post a cooperating agent fee before the sale, obviously, that's the ground rule. But, you know, appraisers use that sold information.
We don't know yet, Bill. I appreciate the question. We don't know yet because that's part of what we do, right? We look at historical figures and we want to know what it is. I don't know if we will continue to have what the offer compensation was on the MLS, because quite frankly, that data has been used against us both by the plaintiffs and the Department of Justice. So I don't know. That's still to be determined.
And I guess just from a practical standpoint, how would you collect it? I mean, you might have, I mean, if the compensation is being paid off the MLS, I'm not so sure it's going to be as easy to track unless you require that it be reported.
Well, I can only speak for the MLSs I belong to. When we change it from pending to close, were there any seller concessions paid? Were there any closing costs? And so, I mean, that's a way that it could be collected. I just don't know if we're going to.
Susan?
I think you're kind of answering my question, but it seems like we've gone from being transparent with our SOC out there on MLS. And now, to me, it feels like we're ripe for discrimination and fair housing violations. And how are we protecting fellow agents and the buyers from those two categories?
You answered your question by asking it. It's a concern. And the plaintiff's attorney didn't care. Quite frankly, I don't think the Department of Justice cares. They think we get paid too much. And so I'm concerned that there's going to be less transparency on this. And as I said earlier, I believe there's going to be some consumers that are harmed because of it. But we're going to have to do our best to navigate through that and be good stewards.
I will say one thing. I think it's interesting, and I don't know if Kevin would agree with this, but you know, for those of you whose news feeds are strictly, you know, realtor settlement discussion, we are at least starting to see some. I'm starting to see some articles that are like, "Is this that great a thing?" So I don't. It's not all. Oh, finally, the realtors are getting, you know, the compensation they've been overpaid for knocked down. I'm starting to see a little bit more, not enough, but more than we had historically. But maybe it's just me.
Bob, before you go, as a heads up, guys, we are a little bit past our time right now. We're going to continue just a little bit longer, as this is an important conversation. But if you have a question, make sure to stand up sooner than later. Bob.
Diane said it said 1:30. So I guess I'm kind of asking for a little bit higher level answer. It seems like we're changing quite a few things, not quite a few things, just a lot of paper that's becoming a pain in the butt. and so much change here and getting to pay 418 million for that is, can I have a little bit of rationale on why we just didn't spend the 418 million and take it all the way to SCOTUS? Is it?
Yeah, I'm happy to talk about that. So what you need to understand is, during any litigation, there are settlement talks throughout, right? I'll tell you that we had settlement talks with the plaintiff's attorney before the trial. We had settlement talks during the trial, and then obviously after the trial. Here's the thing with the verdict and the judgment: $1.78 billion, tripled because it's antitrust, $5.4 billion approximately. If we decided to appeal, we don't have $5.4 billion to post a bond, let alone $1.78 billion. That could have forced the National Association of Realtors into bankruptcy. It could have, Chapter 11. And that would have only protected the National Association of Realtors. We actually believe we would have been successful on appeal in the Eighth Circuit. The problem was that could be a multi-year timeframe to win on appeal. And if we won on appeal, we would likely be remanded back to the lower court for another jury trial. Now, during that multi-year process, all of the copycat suits are continuing. The associations, MLSs, brokerages, and there were some individual realtors that were named in these suits would have to continue to defend themselves with those copycat suits. And so that would have likely caused mass chaos, probably more bankruptcies, quite honestly. And so when we looked at it and said, okay, we still stand by our rules, we're good for the consumer. We have not admitted any guilt or wrongdoing, but we said we need to settle this to put this behind us, and protect as many people as we can. So that's the higher level. I hope that answers your question, Bob.
But I just personally think that, I mean, you know, what was the problem with the verdict? It was, and between the verdict and the settlement, it was, well, now what, right? All this uncertainty and angst. And I get it, there's still some now with the settlement, but at least it's tied to how are we going to implement the changes. We know now what we have to do. And I think having that, you know, amongst all the 1 point whatever it is million realtors, having some certainty as to what the future looks like, even if we still have to figure out exactly the details, is a huge benefit.
Kevin, you on your recent podcast talked about needing surrogates to go out and help communicate with the news media, considering the erroneous news that's out there. Is there a process for that? And how do we make certain that we don't have agents go out and being surrogates that are not to our best advantage?
Yeah, so we've got I think around close to 300 media surrogates across the country at this point. What I would ask you to do, contact DJ or Karn, and they will put you in touch with the right person at the National Association so you can get on the list. His name is Mantil Williams, M. Williams at NAR.realtor, but he's the one that is overseeing that, providing the training, the tools, the resources for these folks that are going to have the conversations with the local media. So yeah, we're definitely interested in having our members tell their story.
All right, we have another question. Or you want on it? That's why I see. I got the code now.
She is on it.
She is on it. Okay, perfect. Do we have another question at all? Okay. One question Jaymie, it goes back to some of the practical applications of not having a posted compensation. The event that different buyer agents are offered different compensation. Can you speak to that a little bit?
Yeah, and that's another one that I think that's definitely a work in progress. And this is another one where I'd love to have Kevin weigh in as he has something is, you know, everything's going to have to be transparent and negotiable. And, you know, I think that I don't think you're going to be required as a listing agent or a seller who's willing to offer compensation to have that amount be blanket uniform across every buyer agent who may call you with a buyer who is interested in the property. There's going to be some discretion. I think to the extent that discretion is going to be exercised, it most likely and probably should be exercised by the seller, maybe in conjunction with the seller agent, where, you know, that whatever offer you're willing to provide to a buyer who calls you up is something that the seller is paying, and you don't get to keep the difference if you know, one buyer agent is going to get this and another buyer agent is going to get this. It's going to be a direct savings to the listing, or to the seller, I'm sorry. But it would appear to me that the discretion will remain to be able to not pay all buyer agents the same compensation. And I don't, Kevin, if you feel differently or think differently, I would be willing to, I'm not certain of that.
I don't have anything to add.
Yeah.
No comment. All right. With that being said, gentlemen, any last closing thoughts?
Thank you. Thank you for being here. Thank you for taking your time to be at this convention, to better inform yourself, or you know, doing what you do back in the community. Just keep up the good work, and if there's any issues or problems that you find, pick up the phone, call DJ. No, but no, thank you. I just want to say thank you.
And you know, I just think we owe a huge debt of gratitude to Kevin. I mean, you know, Kevin could have stepped in and been, and I'm not just saying for appearing here with us, right? I mean, Kevin could have stepped in and kind of done exactly what he was told he shouldn't do, which is give the scripted answers. But for those of you who've followed Kevin on the various podcasts or been on Zoom calls with him, he's very unscripted. He's very honest. He's very fair.
I've gotten my hand slapped a couple of times.
Yeah, but what is it? You're genuine. You're real. And I think, you know, and for the realtor members out there, and I understand some of the attorneys, including myself, might sometimes cringe at this, is that you want some assurances. You want somebody who's going to tell you honestly that things are going to be okay, and they're going to be different, but they're going to be okay. So I just say thank you.
Realtors are resilient. We'll figure it out. You know, things are going to change, but we adapt. Yeah. So I've got a lot of confidence and faith in all of you to adapt.
Yeah, exactly. And my last thoughts, NAR is committed to providing you with the latest information. Guys, less than 24 hours, we had a whole different script that we threw out because we had answers given to us in the last 24 hours. So we will provide the information when we can, the moment we can. So thank you, Karin, for setting this up, and enjoy the rest of the conference, guys.